Can everyone hear me? Okay. My name is Sinette Magnus, and I'm an attorney at the firm Lewis Rice, and I'm so happy that the firm is able to co-sponsor this event with the license collector. This panel is the business, commerce, taxation, banking panel, and so I'm going to try and touch an issue spot on all of those topics to the best of my ability. By now we know there are three bodies of law that govern this area here in the United States. We have federal laws, we have state laws, and then now we have the municipal laws. And we heard the LC talk about the ordinance that's working its way through the city. Same things happening in the county, and many other municipalities have already passed their own ordinances. And so whenever you're gonna think about operating in this space or starting a business, you have to be aware of what's going on in all three areas, all three levels of laws, and what you're doing and how you may be impacted by these laws. We know that cannabis remains a Schedule I substance under federal law. It's legal, there are no defenses. And so we have to wonder, how are we going to continue to operate and maneuver in this space? We have 29 states, I believe, the last time I checked, I haven't checked this morning, but that have medical marijuana laws, and 8 states with recreational marijuana laws. And we know that back in 2013, we had the Cole Memo. Raise your hand if you've heard of the Cole Memo. Okay, some haven't, so I'll run through it. It was basically a memorandum in place under the President Obama administration that directed U.S. attorneys, so that's going to be federal, to take a hands-off approach with respect to the enforcement of cannabis-related federal laws, except under certain circumstances and situations, such as tax evasion, or if the cannabis operation was being used for organized crime, or human trafficking, or there were elaborate home grows with acres and acres in the middle of a forest somewhere. Basically, people that aren't operating in compliance with existing laws in certain states. We also know that under the current administration, Attorney General Jeff Sessions rescinded the memo, and so there's a lot of debate about this and what that might mean. And I guess on the front end, it looks like attorney generals in the various regions within the states have their authority back on what they're going to do and what they're not going to do in terms of enforcing federal laws under the Controlled Substances Act. But there's more than one way to skin a cat, and we also know that Congress, in passing its budgets, have always so far have included restrictions on the use of appropriated funds, and that means the directives from Congress have been that no Department of Justice can use funds it receives from Congress to prosecute cannabis-related crimes in certain states. Illinois and Missouri are among those states listed in Section 537 to prosecute cannabis-related crimes, save in kind of similar circumstances that I just enumerated. So there is that somewhat safety net, but that's not anything that any attorney would advise operators to rely on. So we also have the state licensing process, which I know you've heard about, so I won't go elaborate into that. We'll find out what's required on June 4th, and everyone's going to get to work from there. I really wanted to touch on, I guess what I said, issue spotting, or things that anybody who wants to start a business should be thinking about. I spend a lot of my time working in the trademark area, trademark litigation, people trying to take other people's brands, and that's been a hot topic issue in the cannabis-related industry. How can you get a federal trademark? And the answer, unfortunately, has been no, kind of, And I say that because federal trademarks are federally managed. The United States Patent and Trademark Office is a federal organization. And one of the requirements to get a trademark is that the mark be used in commerce legally. And because cannabis remains a controlled substance, the position of the trademark office is that no federal trademarks for cannabis-related commerce will be issued. Now, some have been able to work around that. I found, and the way that they've done it is they've couched their trademark application around agriculture, or Kush Cakes is a trademark, but right there at the front for brownies that do not contain cannabis. So I imagine that brand might create brownies with and without, but the actual trademark is for products without cannabis. Weed Maps is just a catalog of herbal products. So technically the herbal products are, kind of cannabis related, but that's not what the application says. So there, some attorneys in the space have tried to find clever ways of protecting your brand, but it's still something to keep on the forefront of your mind if you're thinking about starting a business in this space. The second topic is banking, and you're going to hear from somebody in the industry, so I won't elaborate on this, but suffice it to say that banks it's very difficult to find banking institutions that will work with cannabis-related businesses. We have one on the panel. I know of a few others, but there are restrictions due to FinCEN, which is the the enforcement arm of the Department of Treasury that polices marijuana-related businesses. And we've also all heard about SARs and the requirement to report suspicious activity. SARs are suspicious activity reports, and what banking institutions have obligations to report, because again, banking is federally regulated, and many state banks still have some federal affiliation. And so we've seen most banks just take a hands-off approach, and those that are in the industry are willing to work with MRBs, marijuana-related businesses, act as basically vaults. They'll accept cash deposits and give you your money back. But in terms of the ordinary banking services, we haven't seen many willing to provide that level of service. But you'll hear more about that. And some have required NDAs saying, we'll work with you, but you need to assign this non-disclosure agreement that you cannot advertise that you work with us, outside of the ordinary course of business. So that's just another thing to keep at the forefront of your mind. I want to touch on two more things before turning the mic over. The third is real estate. If you're gonna operate in this business, the challenge that many clients have come to Lewis Rice about has been, where can I go? So we have two arms. Number one is going to be all of the ordinances that are coming down the pipeline or have already come have set very specific zoning requirements of where you can do what within a municipality, and we'll see what the city of St. Louis and what the county are doing. The challenge is lots of real estate owners or potential landlords have mortgages. They don't own the property outright. And that means that they're subject to federal banking laws, which means that if their mortgage will say, to the extent that the property is going to be used for the conduction of some kind of illegal activity, you'll lose your mortgage. And so one, if you have property that you're thinking about being a landlord, you need to be thinking about that. And number two is, if you are thinking about starting a business and you want to look out for potential landlords, that's yet another thing that you have to keep on the forefront of your mind. And I can elaborate more if there are questions on that. I've heard some clients come to ask about offshore banking. Some people in the room know that I was born and raised in Toronto, and so people think I have a direct pipeline to Canadian banking. So number one, I don't. Number two is, we've seen Canadian banks make a presence. Some people are Blues fans, and you would have seen the Blues whoop the Bruins last night in TD Garden. That's Toronto Dominion Bank. That's a Canadian bank that has made a presence in the United States. Some people have noticed that CIBC, Canadian International Banking Center, has made a presence into Missouri in the last couple months or so. The challenge is that even Canadian banks that operate in the United States are subject to U.S. federal banking laws. So, and sure, I guess you can fill your suitcase with cash and drive it across the border so long as you disclose it, but that's probably not practical. I think at the end of this panel, and after you hear about from the third panelist, you'll see there's a challenge there is no comprehensive banking solution as of yet, but there's going to have to be, because this is absolutely a $10 billion a year industry. The last two things I want to quickly touch on are formation of a business. Formation's quick and easy. Anything that a business would ordinarily need, a cannabis-related business will also need the same structure and formation requirements. There have been some challenges with investors that are willing to form a business, but they don't want their name associated, and there are ways to maneuver around that. We can talk about that, or happy to talk about how I've seen some in the industry do it. And in terms of taxation, I think that for corporate formation, you really need counsel. We heard the first panelist discuss about how she has exceptional lawyers and accountants in place to help manage your business, and that I highly recommend that, especially at the point of your business formation. We see most businesses formed in the LLC or S corp formation to try and shield personal liability. But one thing to be aware of is we have Section 280E of the Internal Revenue Code, and that basically instructs that a business cannot deduct for ordinary and necessary business expenses for like illegal controlled substance businesses. So that requires, it's kind of two-faced, because it kind of leads to double taxation unless you're wise in how you set your business up. So the right accountant, right attorney will help and guide at that, but you have to be aware of that. But Section 61 of the Internal Revenue Code defines gross income as sales less cost of goods. So what we've really seen is many businesses kind of change and take approaches to what's considered a cost of good to try and adjust what's gross income for taxation purposes. Again, I'm not an accountant and I am not a tax attorney, but these are high-level issue spotting of things that if you want to start a business in this space, you need to be aware of and highly sensitive to and plan. The next panel is going to talk about employment law, so I won't delve into that, but of course one of the big thorns of any business is going to be employees and how to manage that. And we heard the Amendment 14 read that employers are shielded from enforcing wrongful termination suits due to enforcing their zero tolerance drug policies. And that's yet another thing to be aware of. Because that's law doesn't mean that it's constitutional, and it doesn't mean that a court will uphold it or not uphold it. It just means that that's what the law says, or what it's going to say. So employers are highly sensitive to this, and there's been litigation over wrongful terminations all over the country. So this is still a new and evolving space. But one thing I have counseled some clients is, if you have a drug policy, true, there'll be laws that say you can terminate someone who you've done a random drug test and determine that they have traces of marijuana in their system. Everyone in this room knows, though, that when you ingest marijuana or smoke whatever, it stays in your system for a while. So there are challenges with what to do with the information once you've done a random drug test. And the other challenge is when we have, the first person that comes and they test positive and the employer really likes the employee, doesn't want to fire him, so they let it slide. Then they let the second one slide, but the third one, no, they want to fire that person. Well, we're kind of in a different space. We're in, especially if that third person has authority as a medical, uses marijuana for medical purposes, there's the argument that they're in a protected class. So this is a different area of line of employment litigation, and so now the suit is discrimination. It's not a wrongful termination suit, and we haven't seen that body of law develop, but yet another thing to be mindful of. In some states, we have seen employers we are doing away with our drug enforcement policy for marijuana purposes as a marketing tool to attract employees. and it's been highly effective. Needless to say, those are the high-level issues that I wanted to touch on for anyone who's thinking about delving into the area, or who has and has been managing their business without the very involved use of attorneys and accountants. I highly recommend that you rethink that strategy, and that you at least have at the front of your mind some of the issues and intertwining of the different levels of law and types of law that might affect your business. Thank you.
Good morning. My name is Jim Regna. I'm the CEO at Triad Bank. I've often wondered how you become an industry expert in something, and I think I figured it out. You find a startup industry that none of your competitors want to be involved with. So literally we started this 6 months ago, and I've spent most of my time working with the Missouri Division of Finance, which is the state regulatory authority over banks, our attorneys, in terms of trying to figure out how we go about providing banking services to the medical marijuana industry. The two guiding forces for us will be the Cole memo that was spoke about earlier and FinCEN regulations. We are kind of the watchdog at the enforcement level for the federal government. Mitch touched on it earlier. If you put a plan together, follow that plan, because not only will the Department of Health and Senior Services be looking at it, so will we. And we will shut down an account if we see irregularities, not because we want to be the watchdog and the cop, but we need to protect the other people in this industry that are doing things correctly. So the regulators are going to come down very hard on us if we're not following the guidelines that they're providing us. So it is a whole different account than just a normal banking account. It's considered a high-risk account. So we have to background check all the owners initially. We have to file suspicious activity reports initially, just because the industry is illegal at a federal level, so that's suspicious activity. Then we have to file every 90 days suspicious activity reports. We look at the cash coming in and out of the account to make sure that there's no irregularities. We have to see where the cash is coming from, making sure that it's not from any sort of organized crime or any suspicious type of entity, or coming from out-of-state marijuana businesses. So it's very highly, a lot of compliance work that needs to be done internally by the bank. We got involved because we had multiple clients that were looking to get involved. As we began learning about medical marijuana and what we'll call marijuana-related businesses, MRBs, every bank is going to be touched by an MRB one way or the other. It was mentioned earlier about real estate, for instance. If a bank has a client who owns a retail strip center and leases it to a dispensary, they're now an MRB. And a lot of banks are basically freaking out when they see it, and they're asking people to leave. Long-term, good clients asking to leave. So to me, missing out on an opportunity on a new industry that is here to stay, and having to kick existing customers out because of it, doesn't seem like a very good business strategy to me. I think banks need to wake up a little bit and start embracing this versus running from it. There is legislation currently proposed in Congress called the SAFE Act, which would give banks safe harbor, allowing them to bank marijuana-related businesses. There's bipartisan support, but it's still not getting through Congress as quickly as I would like to see, and all of you in the industry would like to see. Mitch and I last night had a conference call with a couple lobbyists that are going to help us lobby our two Missouri senators who have publicly stated that they oppose the SAFE Act. But that is changing in Congress. If anyone's interested, we have a letter that we've put together that explains the banking position and why we should pass the SAFE Act. As many of you that can send that letter to our 2 senators, it would be helpful in terms of lobbying them in this effort. I'm a proponent of the industry. I think for it to be successful, we need banking. And so there's enough business out there for all of the banks who want to get involved. So I'm a lot more open than most bankers are that are doing this. Now that could backfire, and I could have the FBI running to my door here this afternoon, but I don't think so. I think as long as we're following the direction given in the Cole memo and the FinCEN regulations, what would happen is that I would get a letter to say cease and desist, get rid of all those accounts. But I don't even see that happening because there is no funding for enforcement. I think at the federal level, they're looking for a way to make this work. They believe it's, with 33 states having legalized it in some form, it's here to stay. It's too late to enforce. I mean, that ship has sailed. They should have done that when the first state had passed it many years ago. We are limited, unfortunately, in terms of how many accounts we can take. Our state regulators have said they don't want us to have a concentration of more than 20 to 25% in our deposits in the medical marijuana industry. So that will limit us in terms of who we can take. I've encouraged everybody, it's a very lengthy application process. I can't even imagine how many people I've met with. I had 5 appointments yesterday alone on medical marijuana appointments. So I've probably met with 40 or 50 people so far, groups so far, looking for banking services. But I've encouraged them because we are limited in terms of the number that we can take to get their applications in, and because it is a lengthy process, it's very cumbersome in terms of all the information that we'll require to open the account, which is what our regulators are telling us that we have to have. Trying to think of what else. There's so many. Oh, I know what else I wanted to say. On the real estate, the other thing I've learned is that title insurance companies, if they learn that you're using your real estate for an MRB business, they will not give you title insurance. The national title insurance carriers are prohibiting them from writing title insurance for any MRB related business. So I would suggest you talk to your attorneys about this on the front end. You want to be transparent, because if you don't disclose it, if you would have a title policy issue that could void your policy for using the property for something that was prohibited. So I don't have an answer. I just, unfortunately, making you aware of another hurdle that you may face. But I've been telling everyone, consult your attorneys on this issue. Other than that, good luck, everyone. We're trying to help the industry be successful. I've met a lot of great people that are involved, and very intelligent people, very well educated people, and I'm very optimistic on the industry. We just got to get the banking piece fixed, and I'm trying to do what I can to help solve that problem for everybody. Thank you, everyone.
I just would like to say one more thing about banking. When I first started in Illinois, we were fortunate to have a bank step up and take our business. And this was a 100-year-old bank that had clients, like Jim said, that wanted to get into this space. They did the research, they figured out how to do it, and so we all had banking for the first 2 years, so I was spoiled. I didn't really understand the risk until the day that Attorney General Sessions tore up the Cole memo. And that bank, their board, got nervous and decided to pull out. And so I went from having traditional banking service and not even really, understanding how valuable that was, to then watching my young people deal in all this cash, and then this cash having to go with cultivators back to their operation. It is the risk in the system. So if you will please take this letter and get to our Missouri legislators and let them know how important this is. If our states and our governments want transparency, they have to help us get banking, and this is very important. So all of us, anyone who's going to be, involved in this business, it's your responsibility to find a bank and get them educated and do what we can to get all of the operators with a banking relationship.
I'll add one thing just on that. Our board of directors is 100% behind us, which is great. And then we had a shareholder meeting a couple weeks ago where I presented what we were doing. A little nervous, different kind of group, and I was pleasantly surprised on how supportive they were, and especially on the demographic side in terms of the older people that were knowledgeable of medical marijuana and had used it for their own personal benefit. So I think unless they start enforcing, we're, from a management and shareholder standpoint, we're 100% in.
And before we get to your questions, I just wanted to put out here for each of you. So Mitch, if you could elaborate on what it's like to be a business owner in Missouri and navigating that space in the hemp oil and soon-to-be medical marijuana field. Sanette, if you could actually elaborate more on the employment piece. I know the next panel is going to get into ethics, and we'll get into some of these topics with Dr. McCarthy and Dr. Vo, but from the standpoint that having a business owner here, having the navigation piece, if you could speak on that a little bit more. And Jen, could you speak to the dangers and the complications in working in the cash industry with a product as popular and obviously as fungible as medical marijuana? So if you three can answer that before we get into the questions, that'd be fantastic.
So I mentioned that we have this CBD operation that we are operating under a very narrow law. It has been both challenging and rewarding, as I said, just dealing with these patients and providing them some sort of benefit when sometimes all hope is lost because other medications are not working for them has been wonderful. The other thing that I'm very excited about with this new law is the number of jobs that it's going to bring to the state of Missouri. And I've been watching the rules change over time, and I'm watching how they're trying to potentially push these businesses into areas that are underserved. And I do know that people are looking in those locations to hopefully bring along some of the people who have been damaged by the war on drugs. So kudos to the department for figuring out really how to spread the workforce around the state. I'm very excited about the prospects for the state of Missouri. The conditions that we cover in Amendment 2 and now the Constitution are great conditions. And with chronic pain being part of that, we all know so many people suffer from chronic pain. And as I watch what's happened in our dispensary in Chicago, I will tell you we have about 1,400 patients right now, and almost 50% of those patients are working to get off opiates with cannabis. And, it has been just astounding to me to see how this helps with chronic pain and the stories that people tell about getting their life back, being able to be a parent again and be present, to be able to work and not have the side effects of those pharmaceutical drugs. We've witnessed in our own operation, sometimes people come to us, little kids come to us with 5 and 6 of the most dangerous, powerful anti-seizure meds all mixed together. And in working with Cardinal Glen and Children's Hospital, it's their desire to try to detox these kids off some of these harsh medicines. So while all of the regulatory hurdles are daunting, and you do need to be good business people and follow the law, and there's lots of laws, it is a rewarding business at the end of the day, and I encourage everybody that has a desire to try to get in.
Well, switching gears entirely, I was trying to think, how can I segue from a rewarding business? Well, you can be a rewarding employee of a company that would hopefully be supportive of this industry. You know, Jim, I'm not surprised that your shareholders are supportive, given that the volume of business and potential for your bank. So kudos to you for wanting to be on the forefront. You know, our research indicates that, you know, some states are collecting north of $20 million a month in tax revenue from the industry. So we don't know what the revenue will be for Missouri, but that's a lot of money. And I'm not talking about what the cities or the municipalities are going to collect in taxation. I'm only talking about the state. JP asked that I talk about employment law. So I prepared, you know, some of the main questions that we have gotten from different union groups, as well as you know, major employers in Missouri. And you know, based on our research, you know, here are the answers. The questions have been, you know, can a company continue to have a zero tolerance policy of drug use in their employees? And the answer is yes. Can a company engage in random drug testing? Yes. Does a company need to make accommodation in the case of a medical marijuana user? And I think that the answer is somewhere between no and probably not. You know, and it's a question that I often get from non-lawyers, and I try and explain this. Just because something's a rule or the law and it's broken, or because you can do something, doesn't mean that you should. You know, anybody can sue for anything. You know, and that's something that, you know, on both sides of this space need to be aware of. I don't know if they'll win or not, or if a judge will agree, but because you do something and you have a policy that says you could or you can't, doesn't mean you won't be sued, and it also doesn't mean you won't lose. We obviously, because we're not there yet in Missouri, we have to look at what's been happening in other states, and we have had, you know, a case go up in Massachusetts all the way up to the Supreme Court, where an employer enforced their zero tolerance drug policy. The employee sued under a theory of discrimination as well as wrongful termination. The lower court dismissed the case, said you know, they're allowed to have this policy, that's our law, you know, case dismissed. They appealed, case dismissed. It went up to the Massachusetts Supreme Court, reversed. You know, so unfortunately, because of how the case was postured, there was no legal reasoning on the arguments made by the terminated employee, you know, that other states can look at. But because there is a zero tolerance policy in place, and because you enforce it and terminate, if that employee somehow has access to millions of dollars to sue all the way up to the Supreme Court, which there are private donors that are willing to fund this litigation to help to create this body of law, doesn't mean that you'll win. And that's just something that employers need to be aware of. I think I already discussed a circumstance with, if you have a policy, either you're going to have a policy or you're not. Either you're going to enforce your policy or you're not. But piecemeal enforcement's where you're going to get yourself in trouble, or opening yourself up to higher likelihood of lawsuits being brought. I guess I'd turn it to the attendees. If there is a specific employment-related question you have, I'd be happy to try to address. Yes, Ms. Thompson.
Yes, I do have a question. My question is, should we, if we don't have a policy now, should employers develop such a policy that includes medical marijuana, or just leave it be? You're my counsel for today.
Here's what I'll say. There are drug-related policies that different government entities. Are you with the government right now?
Yes.
Okay. Yeah. So then my best advice would be, there should always be something in place. Now, I would likely advise, hypothetically, if a licensed collector were to ask a law firm, hypothetically, or anybody in, municipal, state, or even federal government, we start with what's the end result? What are you really trying to accomplish? And is medical marijuana use something that you're trying to police? And then we work backwards from there. But unfortunately, with the landscape and in this space, there is a opioid crisis. There is a need for probably some form of drug-related regulation in the workforce or in the workplace amongst employees. And I think it's not the best practice to have nothing in place.
And I'll go just a little bit further.
I knew you would.
I had a question earlier, and so, for instance, in my particular area, we have drivers that go out. There also are compliance and security issues because they handle funds and different things like that. And so, with that policy being in place, I know it gives us a little cover, but just what about someone that's not in government? But right now, I'm talking about drivers, security officers, compliance officers, folks that do those types of jobs as employment.
My understanding is that because though they're technically not government employees, they're acting as if they were, therefore the very same regulations that would apply for government employees. There's case law that would extend it to those individuals, but I would have to look specifically and just double check exactly the application of that case law, that body of law, to give you the best advice.
And one last follow-up. And so in developing my policies and procedures, I look to legal counsel.
Absolutely.
Thank you.
Sorry.
So, JP asked me to speak about the safety issues related to not having banking access. And so obviously you have to do something with the cash. And it's a cash business because there's no merchant processing, meaning you can't use your debit card or credit card. So there's, in a society that's gotten away from using cash, this is an industry that's dependent upon cash. And when I spoke with the Missouri Division of Finance, the Commissioner of Finance is a gentleman by the name of Lee Keith. He said that he was very supportive of banks getting involved in this space because he was very concerned about the public safety issues. I think most of us have read about the armed robberies and the theft and all of the other issues that go on when it's a cash business, and it's hard to monitor cash. You get theft internally. You have people that are, we're worried as a bank that people are going to think we're sitting on all this cash, which we won't. By the way, we're going to work with Armored Car Services and have it go straight to the Fed. But which is kind of another interesting thing, is that it's illegal at the federal level, but yet the Fed will accept the cash. So, not complaining, but just ironic. So really, and the other thing is transparency, that banks allow you to make sure that the business owners are doing things correctly. And I've met with multiple groups who have had experience in other states, and the experiences haven't been good because of the issues that people sell in the black market. They do other things that are not an unfair competitive advantage. So the real strong operators embrace the compliance and the banking transparency. They want to do it right. And so in order for this industry to be successful, we need to make sure we have the proper oversight involved. And banking, like it or not, and we're used to it, we get to police a lot of different things for the government. So we're used to doing it, but it is a huge issue not to have banks involved and have the amount of cash floating around that is dangerous.
JP, I didn't hear the last part. What's the legal recourse that? To send cash. That is a good question. I don't know. You know, I think the hypothetical is that you know, there's cash that is collected for, you know, the operation of a dispensary, and then somebody goes and robs that person for that cash. You know, will the person be prosecuted for robbery? Right? That's the question. I suppose there would be enough statutes that assuming that the amount exceeds, and now we're in federal jurisdiction, though the Department of Justice has the directive from Congress not to use appropriated funds for cannabis-related prosecutions, this is not I suspect that here in the Eastern District of Missouri, the argument would be it's not a cannabis-related activity directly, that's just derivative, you know, that's over here. This is a robbery, and they'd fall under those separate statutes, and that there's a chance that it would be, prosecuted. Now, upon the successful prosecution, I don't know that the U.S. Attorney's Office here in the Eastern District of Missouri wouldn't then turn around and immediately prosecute and then take those proceeds as illicit proceeds from an illegal activity. You know, I think that would be a double-edged sword, but that's just my best guess, based on what I know about our current leadership here.
Yeah, I would say you still have state charges.
Well, yeah, but I know it's JP, and he's really just talking about what would the Department of Justice do. Of course, there's going to be state, and who knows, probably there's a city violation too that Attorney Gardner could probably prosecute as well.
Why we need banking?
Yeah, people get prosecuted regularly for robbing drug dealers, which dealing in illegal drugs is illegal. So you would still have state charges that could be applicable for somebody that would go in and rob a dispensary, even though the federal government may not recognize it.
Gosh, thank you.
A couple minutes.
Hi, this question's for Jen. I just want to say I appreciate Triad kind of filling that void in the state of Missouri. But for people out here who might want to start a business, who maybe haven't thought about this, you have a lot of additional compliance issues as well as liability. So from a banking fee standpoint, this is going to be a different structure than a normal, you said it's high risk. Can you touch on that a little bit?
Because the pricing on these accounts are different. Initially on what we're calling the pre-MRBs, this is when we start doing the background checks and all the other compliance things, it's $2,500 to open the account, and that gets you the pre-MRB account. We are still working on how we will price the MRBs, but what I've been telling people is we want to cover our costs, make a fair profit, but not gouge anybody, because I've heard the stories of banks and credit unions that have gotten involved that have taken advantage and gouged the medical marijuana clients. That's not our goal. We want to build relationships. What we've asked is that when the opportunity exists, bring us non-MRB business, and we'll focus on building a relationship. But as we know, in any sort of relationship, if you take advantage of somebody, it's probably not going to be a very good relationship for very long. So I don't have the final pricing on the MRBs, but it will be fair.
Unfortunately, sorry, Andrew. Unfortunately, I'm running kind of tight, so we're going to adjourn this panel. take one last break before we get to our last panel. Let's give this panel a round of applause. Thank you, Mitch. Thank you, Samet. Thank you, Jim. They'll be sticking around for a few moments. Andrew, you can ask your question personally if you guys want to sign on to this letter or these petitions for our senator.